Hello, everyone. Welcome to the USA Immigration Update. Breaking news from the USA Immigration Update. Congress has officially passed one of the most comprehensive immigration reform packages in modern U.S. history, a measure that experts are calling the most significant change to immigration law in decades. The bill, which received rare bipartisan approval, introduces sweeping adjustments that redefine how the federal government classifies, screens, and enforces immigration laws across the nation. Welcome to USA State. Please make sure to subscribe, like, and share this update so you never miss critical national news from Washington, the states, and the agencies shaping America's immigration future. Lawmakers on Capitol Hill have taken what many believe to be an impossible step, bridging political divides to produce a broad immigration reform framework. Supporters call it balanced and necessary, while critics warn it could transform how millions of lawful immigrants, workers, and students experience life in the United States. At the center of the legislation is a complete reclassification of all non-citizens. For the first time, the law unifies temporary visa holders, permanent residents, and long-term green card holders under one enforcement category. In practice, this means that legal distinctions once considered protective may no longer guarantee security from immigration action. For millions of green card holders, this represents a fundamental shift. Under previous rules, lawful permanent residents could generally expect stability unless they face serious criminal convictions. That assumption no longer holds. The new legislation introduces expanded deportation standards tied directly to public safety offenses, including driving under the influence. Under the new federal standard, a single DUI incident, even one treated as a misdemeanor under state law, can serve as grounds for deportation. Legal. Experts explained that this measure reflects the Trump administration's long-standing emphasis on public safety accountability, classifying DUI behavior as incompatible with lawful residence privileges. The most debated provision extends enforcement authority even further. The law now allows removal proceedings to begin without a formal conviction. Legal analysts note that even an admission of conduct meeting the definition of a DUI could, under certain conditions, lead to immigration action. Congressional leaders defending the measure describe it as a firm but fair safeguard designed to protect American communities. They cite federal data showing that alcohol-related driving incidents claim thousands of lives annually, arguing that higher accountability standards are consistent with the responsibilities of lawful residents. However, immigration advocacy organizations express concern that the expanded authority may lead to inconsistent enforcement or deter individuals from reporting incidents to authorities. They caution that even minor infractions could now carry life-altering consequences for families who have otherwise complied with every aspect of U.S. law. Two key pillars define this reform package. The first is the expanded grounds of inadmissibility. Under the new framework, any individual who has a DUI conviction or who admits to conduct meeting that threshold will be deemed inadmissible to the United States. This impacts both those seeking entry and individuals already in the country applying for renewal, adjustment, or citizenship. Immigration attorneys confirm that even those who serve no jail time may be affected, as the standard now classifies DUI behavior as a serious moral and legal violation. The second pillar involves tighter deportation standards. Regardless of how individual states categorize DUI offenses, federal immigration law will now supersede state definitions. A misdemeanor at the state level can still qualify as a deportable offense under federal rules. The implications reach across every visa category, from employment-based petitions to family-sponsored immigration. For years, many immigrants viewed permanent residency as a final stage of security. This legislation, though, kind of redefines that assumption. Green cards are now described by federal authorities as conditional privileges that can be revoked upon violation of public safety standards. The reform also modifies the definition of good moral character, which has been a long-standing requirement for U.S. naturalization. Under the new criteria, A single DUI conviction automatically disqualifies an applicant from obtaining citizenship. Legal experts say this codifies an interpretation previously applied in parts of the immigration system, but now makes it universal. So consider a common scenario cited by attorneys. Imagine a permanent resident who has lived in the United States for over a decade, paid taxes, raised a family, and maintained steady employment. Under the old legal structure, a single DUI incident would have been managed as a personal or legal issue without necessarily affecting immigration status. But under the new rules, that same offense could result in deportation or permanent ineligibility for citizenship. Immigration lawyers across multiple states are now advising clients to seek legal counsel before renewing status or filing naturalization applications if any prior DUI history exists. They warned that the reform allows for retroactive review, meaning older cases could be reconsidered under the updated standard. The Department of Homeland Security and U.S. Citizenship and Immigration Services are expected to release additional operational guidance in the coming weeks to ensure consistent nationwide enforcement. In the meantime, many individuals and families remain uncertain about how past incidents may be evaluated. Congressional supporters argue that the measure will restore public trust in the immigration system. They emphasize that law-abiding residents have nothing to fear and that the reforms simply align immigration law with public safety expectations. Opponents, however, maintain that the lack of proportionality could make the system overly punitive. They point out that state laws already address driving offenses, and adding federal immigration penalties creates overlapping consequences that may disproportionately affect certain communities. The Trump administration has described the reform as a cornerstone achievement in its national immigration agenda. Officials highlight its dual purpose, strengthening public safety while streamlining administrative processing for compliant applicants. Within the same legislative framework, Congress has also approved modernization measures aimed at improving USCIS efficiency. The US law allocates funding for digital case management, faster adjudication of high-demand employment visa categories, and the expansion of online filing systems. These provisions are designed to reduce long processing times that have frustrated applicants and employers alike. Yet, despite these positive administrative steps, many advocacy groups say the enforcement provisions overshadow the progress. They urge federal agencies to apply discretion, differentiate between serious criminal behavior and isolated incidents, and ensure that humanitarian considerations are not overlooked. Federal immigration offices abroad, including consulates and the National Visa Center, are already preparing to implement stricter background checks and verification procedures. Analysts expect this to temporarily slow visa issuance, particularly for categories requiring in-person interviews or extensive documentation. Across immigrant communities, the impact is immediate. Green card holders are delaying travel plans, fearing that overseas trips could trigger re-entry complications. Applicants awaiting renewal or adjustment of status are, seeking legal reviews of their records to ensure compliance with the new rules. International students and professional workers under temporary visas are being advised to maintain strict adherence to all state and federal laws to avoid potential complications. The emotional and social impact is substantial. Community organizations report a surge in inquiries, legal consultations, and requests for clarification. Many families are focused on understanding the new risks and making sure that their loved ones remain in good standing. Experts agree that the next several months will determine how this reform shapes the U.S. immigration landscape. Much will depend on how enforcement agencies interpret admissions of conduct and how broadly they apply the new deportation triggers. The Department of Justice and DHS are expected to issue detailed policy memos to clarify enforcement boundaries. At its core, the new immigration law represents a decisive shift towards stricter compliance and uniform standards. While it introduces some modernization benefits for legitimate applicants, it also narrows the margin for error across every visa category. Legal analysts describe this as a new era, one in which only full citizenship guarantees lasting security. For all others, including students, skilled workers, and long term residents, the expectation of flawless compliance has never been higher. For now, immigration attorneys recommend caution, awareness, and full legal transparency when filing any petition or renewal under the revised law. They stress that understanding the specific provisions can prevent unnecessary risks and ensure lawful status continuity. This concludes today's coverage on the U.S. immigration reform law. For ongoing updates, regulatory clarifications, and official announcements, keep watching USA Immigration Update. Please don't forget to subscribe, like, and share this report to stay informed on the latest developments shaping U.S. immigration, federal policy, and national governance. Thank you for watching Immigration Update, your trusted source for verified professional and